Mr. Chair, members of the committee, ladies and gentlemen, it is an honor for me to be invited to discuss the issue of unaccompanied migrant children with you. When states talk about the rights of all children around the world, in which all girls and boys can enjoy childhood, where their safety and well-being are paramount and where they can develop in health, peace, and dignity, in many cases, this is not seen to apply to migrant children. Migrant children are often overlooked in the development of national laws and policies addressing migration, and the situation is more dire for migrant children in an irregular situation who are often treated as criminals. Despite the existence of international laws designed to respect, protect, and fulfill all children's rights, states have yet to fully implement these rights for the migrant child and often overlook the migrant child as a distinct rights holder in developing migration laws and policies as well as child protection policies. At the core of this is the fact that migration is often seen by states as a problem which needs to be overcome. In this context, the rights of migrants are often viewed within very narrow parameters, as only being legitimate where the migration is the result of a specific circumstances. This includes migration as a reaction to an emergency situation, such as the movements of asylum seekers and refugees, or in other circumstances of forced migration, such as natural disasters, or where related to exploitation, such as the case of victims of trafficking. While these emergency situations are of great importance, it is important to recall that migration in general, and the migration of children in particular, takes place in a range of circumstances broader than these contexts. Child migration has multidimensional root causes. On the one hand, factors that compel children to migrate may include persecution of the child or of the parents, post-conflict or post-natural disaster humanitarian crisis, trafficking in various contexts and forms, including the sale of the child by the parents. Yet, beyond these reactive circumstances, migration is also a way for children to seek a better future for themselves, either together with their parents or alone. Migration is often seen as a way to escape poverty and discrimination, including a way to better access essential rights and services. Focus should thus be on ensuring the best interests of the child as a primary consideration during all stages of the migratory process, notwithstanding the reasons for migration. In light of the above, there is not one homogeneous profile of the migrant child due to the varied parameters of their situations. Migrant children may be accompanied by their parents or guardians, or by either adults, they are separated children then, or they may come alone as unaccompanied children. Children may migrate in a regular way or in an irregular way. Irregular migration may involve irregular entry by the children into a third country, but will also include those children who enter a country regularly, but who overstay their visa or end up in an irregular situation in other ways. Migrant children also include those children who are born in host countries to migrant parents and do not get citizenship. Children left behind by parents who migrate are also affected by migration, and they may in turn end up as migrants themselves, seeking to reunite with their families. Sometimes the absence of opportunities for children to migrate safely and through regular channels leads them to embark on dangerous journeys, including through the use of smugglers, in order to reach their country of destination. Especially when unaccompanied, these children are highly vulnerable to becoming victims of violence and abuse during their migratory journeys. Opening up more regular migration channels would go a long way in protecting these children. Unaccompanied or separated children are particularly vulnerable to becoming victims of human rights violations, such as sexual and economic exploitation and trafficking, and their situation requires special attention. Unaccompanied and separated children on the move face greater vulnerabilities and risks, including discrimination, sexual and other forms of violence, and being coerced into begging, drug dealing, or prostitution by criminals or criminal organizations. Irregular migrant children face numerous obstacles and challenges during and after the migration process and are in a situation for which they should not be held responsible, neither morally nor legally. As one of the most vulnerable groups in society, these children need respect, protection, and fulfillment of their fundamental rights. To begin to achieve this, all persons under the age of 18 must be recognized as children in the eyes of the state, the law, regardless of their immigration status. The lack of distinction between adult and child migrants is therefore a major challenge that a number of states still have to overcome. National migration laws do not always include a child rights perspective and usually lack specific provisions on children. Additionally, most public policies on child protection do not yet include the specific needs and protection to be afforded to the child in the context of migration. The treatment of migrant children as adults may lead to harmful practices, for example, when irregular migration is criminalized, or when deportation and detention procedures do not comply with the protection that should be given to children in those circumstances. States can begin to protect migrant children and uphold their fundamental human rights by bringing this perspective to the forefront in law and policy development. In this respect, regularizing migration processes are an important tool to enhance the respect for the human rights of migrant children in an irregular situation. Several international treaties afford children rights that are or can be affected during or after the migration process. At the foundation of the international framework on human and children's rights is the Convention on the Rights of the Child, which prescribes minimum standards which states must adhere to regarding the treatment of children in their territory. The CRC, which is the most widely ratified human rights treaty, provides in Article 2 that all rights contained in the Convention apply to all children within the jurisdiction of the state parties without discrimination of any kind. Article 3 provides that the best interest of the child shall be a primary consideration in all actions concerning children. Article 6 sets out the right to life, survival, and development of the child. Article 12 provides that children have the right to express their views and the opportunity to be heard in judicial and administrative proceedings affecting them. The effective application of these four general principles of the CRC would go a long way in ensuring the respect for the human rights of all children in the context of migration. However, unfortunately, in practice, these rights are often violated, and there is a broad range of human rights challenges affecting children in the context of migration. One example is the extensive criminalization of irregular migrants, including children. This can lead to serious restrictions on their human rights, including restricted access to certain rights and services, such as education, housing, and health care. For example, where countries require registration with a government authority to access certain public services, this will inhibit access for individuals not regularly residing within the state. Migrant children may also experience restricted access beyond express prohibition through informal barriers due to financial costs, lack of information, discrimination, or a climate of fear of discovery and detention or deportation. Migrants may also be reluctant to use public services or allow their children to access these services as a result of state policies which formally criminalize irregular migration. A related consequence of the phenomenon of criminalization of migration is that it promotes the application of inappropriate terminology, calling migrants in an irregular situation illegal. Using incorrect terminology that negatively depicts individuals as illegal contributes to the negative discourses on migration and further reinforces negative stereotypes against migrants. Moreover, such language legitimates a discourse of the criminalization of migration, which in turn contributes to the further alienation, discrimination, xenophobia, and violence against migrants, including migrant children. However, no child is illegal, and all children have rights regardless of their migratory status. The world appears to be facing an increasing number of children in migratory situations. However, the statistical data available is scattered and problematic. States should thus considerably strengthen their data collecting and analyzing capacity regarding migrant children in all phases of the migratory process in order to allow them to formulate and implement child-sensitive migration policies. Lack of awareness and training of relevant authorities is a contributing factor to the massive human rights violations committed against separated and unaccompanied children. Capacity building for border officials, legal representatives, guardians, interpreters, and others dealing with separated and unaccompanied children working is therefore an important measure to enhance the protection of the human rights of migrant children, particularly those in an irregular situation. Such training should include relevant international law, interview techniques, awareness of the violations that may have taken place during the migration journey, which would have an impact on the child's psychology and behavior, cultural sensitivity, and intercultural communication. The lack of a best interest determination procedure may also lead to a number of human rights violations, including the detention of children and their deportation, as well as separation of children from their parents, disrespecting the principle of family unity. Detention of migrant children, as confirmed by the Committee on the Rights of the Child, is never, ever in the best interests of a child. Children in immigration detention will often be traumatized and have difficulty understanding why they are being punished despite having committed no crime. According to Article 37b of the Convention on the Rights of the Child, no child shall be deprived of his or her liberty unlawfully or arbitrarily. In its General Comment number 6 on the treatment of unaccompanied and separated children outside their country of origin, the Committee on the Rights of the Child stated that unaccompanied and separated children should not, as a general rule, be detained, and detention cannot be justified solely on the basis of their migratory or resident status or lack thereof, nor should they be criminalized solely for the reasons of irregular entry or presence in the country. In its 2010 report to the Human Rights Council, the Working Group on Arbitrary Detention stated that, given the availability of alternatives to detention, it is difficult to conceive of a situation in which the detention of an unaccompanied minor would comply with the requirements stipulated in Article 37b of the Conventions on the Right of the Child. States should instead appoint a guardian as soon as the unaccompanied or separated child is identified and maintain such guardianship arrangements until the child has either reached the age of majority or has permanently left the territory or the jurisdiction of the state. It is my opinion that the obligation to always consider alternatives to detention, non-custodial measures, before resorting to detention should be established by law. Detailed guidelines and proper training should be developed for judges and other state officials, such as the police, border and immigration officers, in order to ensure a systematic application of non-custodial measures instead of detention. When considering alternatives to detention, states must take full account of individual circumstances of the migrants, and especially of migrant children, both accompanied and unaccompanied. Non-custodial measures should be subject to legal review, and migrants who are subject to non-custodial measures should have access to legal counsel. As noted in my report to the Human Rights Council in June 2012, states should ensure that legislation does not allow for the detention of unaccompanied children and that detention of children is permitted only as a measure of last resort and only when it has been determined to be in the best interest of the child for the shortest appropriate period of time and in conditions that ensure the realization of the rights enshrined in the Convention on the Rights of the Child. Children under administrative detention should be separated from adults unless they can be housed with relatives in separate settings. Children should be provided with adequate food, bedding, medical assistance, and granted access to education and to open-air recreational activities. When migrant children are detained, the United Nations rules for the protection of juveniles deprived of their liberty and the United Nations standard minimum rules for the administration of juvenile justice should be strictly adhered to. Children under administrative detention should be separated from adults in conditions. In addition, the gender dimensions and issues regarding family unity, where siblings are migrating together, should also be taken into account. With regard to the deportation of children of migrants and the importance of respecting the best interests of the child in such procedure, it is my belief that children should only be repatriated if it's approved through a legally exhaustive process to be in the best interest of the child in order to allow for family reunification. The same reasoning should apply to allow children to stay in the countries of destination. States must thus mainstream a child's rights-based approach to migration into national legislation, plans, programs, and policies, and consider the impact of migration on children in the elaboration and implementation of national development frameworks, including with respect to poverty reduction, rights protection, and access to public services. A comprehensive child's rights-based approach to domestic law and policy would ensure that minimum obligations under the CRC are met and would utilize the best interest of the child as a key evaluation tool in the decision-making process. Such an approach must ensure that laws are specifically tailored to the issue of migrant children, unaccompanied and accompanied, in order to allow for age-appropriate due process of law, including, inter alia, rights to a guardian, a legal representative, free legal aid, access to jurisdiction, effective remedy, an interpreter if necessary, and the right to be heard. I am sure that this is only the beginning of our joint efforts to identify the current gaps and enhance the respect, protection, and fulfillment of the human rights of all children, especially unaccompanied children affected by international migration. I remain at your disposal if you require any additional assistance from me and wish you a productive discussion. I thank you for your kind attention.